customary one argument, recognizing how difficult and important the issues would be. And the government made a motion to close the argument to the public and press, saying that what has to be discussed here, the content of the Pentagon Papers, is too sensitive to air in open court. Therefore, the argument should be conducted in camera, that is, in secret, behind closed doors. And the court considered that motion by the government and denied it by a vote of 6-3. 3 justices would have completely closed the argument to press and public. And so we arrive on that Saturday morning in June. Take a break. Let me get this up and we'll do it. Stand up and stretch or something. Do something else.
It is important, I think.
So here's what the court looked like in 1971. I got them ranked here, sort of in my idiosyncratic judgment, in order of their sensitivity to First Amendment values. The Chief Justice at the time, Warren Burger, we've met him before, appointed by President Nixon, not so long before the Pentagon Papers case, very conservative, very pro-government, hostile to the press in general. Then there's Harry Blackmun, who was almost brand new at the court at the time. He too came from Minnesota, as Burger did, and when he was appointed by President Nixon, he was viewed as sort of a weakling who would follow Burger around, and whatever Burger wanted to do, Blackmun would likely vote with him. They were called the Minnesota Twins. They actually had known each other since boyhood. And Blackmun was a middle-of-the-road Republican type in 1971 when he joined the court. This is before he wrote Roe versus Wade, which was a radicalizing experience for Blackmun. And Blackmun became, as you know, over the time he served in the court, became what passes for a liberal in the Supreme Court, largely because of the reaction to his having written the Roe versus Wade decision. But in 1971, you had to figure that Blackmun was not going to do anything important that Burger didn't want him to do. And then John Marshall Harlan, the author of the Cohen Fuck the Draft case, was a very principled judicial conservative who didn't want cases decided any more broadly than need be, but he wasn't political at all. He was just a very cautious, scholarly, thoughtful justice. Byron White, we've already heard from him. We'll hear from him again. He was no friend of the press at all. He happened to be a Democrat appointed by President Kennedy, but he was no big First Amendment guy, and certainly not friendly to the press. Right in the middle, and in the middle time after time, was Justice Potter Stewart, often a swing vote on the court in 5-4 decisions. He was a Republican who'd been appointed by President Eisenhower in the 50s. He was interested in press issues, paid a lot of attention to them, was friendly to some reporters, including Nina Totenberg, who reports on the Supreme Court for NPR. And if you're to win this case on the First Amendment side, basically you've got to get Stewart. Then on the left wing, Thurgood Marshall, the greatest civil rights lawyer of all time, something about what he thinks about First Amendment issues. We know that he's very skeptical of government justifications on limiting civil liberties and so on. William Brennan, the architect of the modern First Amendment, having written a lot of strong First Amendment decisions, including New York Times versus Sullivan 7 years before this, in 1964. And then Justices Black and Douglas. Hugo Black was a senator from Alabama when he was appointed by President Franklin Roosevelt in the 30s to the court, a long-serving justice. And William Douglas, also appointed by Roosevelt back in the 30s. And these two were First Amendment absolutists who took literally the words of the First Amendment, Congress shall make no law abridging the freedom of speech or the press. So they were not likely to be on the government side in this case. The lawyers in the case, Alexander Bickel, who represented the New York Times, a professor from Yale, William Glendon, who represented the Washington Post. I edited him out of this of the argument in the Supreme Court. The lawyer for the government in the case, arguing for the government, was Erwin Griswold, the Solicitor General of the United States, the lawyer for the government who argues the government's case in the Supreme Court. Erwin Griswold was a scholar. He had, for a long time, been dean of the Harvard Law School. He was probably nominally a Republican, but he wasn't partisan in any way. He was extremely honest. He had great credibility with the court. That is, the court would likely take Griswold's word for it. They trusted him. He wasn't trying to pull anything, put one over on anybody. He'd say what the position is and why it is. And that's the way he was perceived by the court, as somebody who didn't have a particular agenda, was doing an outstanding job of representing the United States. So here we are in Washington on that Saturday morning, in open court, finally. This is the way these folks looked in those times. This is Black and this is Douglas, the absolutist, Burger in the middle, Brennan on that end, Blackmun above him, White, Stewart, the swing vote, Marshall, and Harlan. And so Erwin Griswold, the Solicitor General, gets decked out for these arguments with his cutaway. It's their uniform for arguing in this striped pants. And he gets up to argue the case, and here's what he says. As I say, I've edited the argument. It was 2 hours of argument. I've got it way down. It's a little clumsy in part, but I think it captures the essence. So let's see if I can pick it up here.
To get this case in perspective, the case, of course, raises important and difficult problems about the constitutional right of free speech and of the free press. And we've heard much about that from the press in the last 2 weeks. But it also raises important questions of the equally fundamental and important right of the government to function. Great emphasis has been put on the First Amendment, and rightly so. But there is also involved here a fundamental question of separation of powers in the sense of the power and authority which the Constitution allocates to the President as Chief Executive and as Commander-in-Chief of the Army and Navy. And involved in that, there is also the question of the integrity of the institution of the presidency. Whether that institution, one of the three great powers under the separation of powers, can function effectively. The problem lies on a wide spectrum, and like all questions of constitutional law, involves the resolution of competing principles. If we start out with the assumption that never under any circumstances can the press be subjected to prior restraint, never under any circumstances can the press be enjoined from publication, of course we come out with the conclusion that there can be no injunction here. But I suggest, not as necessarily conclusive in this case, but I suggest that there is no such constitutional rule, and never has been such a constitutional rule.
Understand, however, that your brother counsel on the other side really questioned any of this. I thought that at least for purposes of this case, they conceded that an injunction would be not violative of the First Amendment, or put it this way, that despite the First Amendment, an injunction would be permissible in this case if the disclosure of this material would, in fact, pose a grave and immediate danger to the security of the United States. That is, that for purposes of this case, they've conceded that, but they have said that, in fact, the disclosure of this material would not pose any such grave and immediate danger.
Mr. Justice, if they have conceded it, I am glad to proceed on that basis.
No, I'm not conceding it for them, but that has been my understanding of what the issue is. They'll make it clear.
I may say that their briefs were served on me within the last 15 minutes, or last hour, which was entirely in accordance with this court's order, but I have not seen their briefs. I do not know what is in their briefs.
In other words, I had thought in my analysis, and I haven't had the benefit of much more time than you've had, that this basically came down to a fact case, that the issues here are factual issues.
And that, Mr. Justice, is extremely difficult to discuss
here in this open court. I understand it, Mr. Solicitor General, and you tell me, please, if I misunderstand it. Your case doesn't really depend upon the classification of this material, whether it's classified or how it's classified. In other words, if the New York Times and the Washington Post had this material as a result of the indiscretion or irresponsibility of an Undersecretary of Defense who took it upon himself to declassify all this material and turn it over and give it to the papers, you would still be here.
I would still be here, but would have one string off my...
I didn't understand it was a real string.
Well, maybe it isn't, but there are those who think it is, and I must be careful not to concede away in this court grounds which some responsible officers of the government think are important. But I do not
exactly understand, and tell me if I'm wrong again, that your case really doesn't depend upon any assertion of property rights, by analogy to the copyright law. Your case would be the same if the New York Times had acquired this information by sending one of its employees in to steal it, as it would if it had been presented to the New York Times on a silver platter.
Yes, Mr. Justice, but I don't think that literary property is wholly irrelevant here. But my case does not depend upon it.
Your case depends upon the claim, as I understand it, that the disclosure of this information would result in an immediate grave threat to the security of the United States of America, however it was acquired and however it's classified.
Yes, Mr. Justice, but I think that the fact that it was obviously acquired improperly is not irrelevant in the consideration of that question.
I understand. You're not claiming that you're entitled to an injunction simply or solely because this is classified material.
No.
Nor do I understand it that you're claiming that you're entitled to an injunction because it was stolen from you, that it's your property. You're claiming rather, and basically, that whether or not it's classified, or however it's classified, and however it was acquired by these newspapers, the public disclosure of this material would pose a grave and immediate danger to the security of the United States of America, period.
Yes,
Isn't that correct?
Yes.
So declassification of doesn't have much to do with the basic issue, does it?
I agree with you, except that it's part of the setting. If this material had never been classified, I think we would have a considerably greater difficulty in coming in and saying, well, for example, suppose the material had been included in a public speech made by the President of the United States.
Well, it would be in the public domain already.
All right, but we come in and say, you can't print this because it will greatly affect the security of the United States. I think we would plainly be out.
Have a very shaky case on the facts, and that's...
Or suppose it had been...
And this, therefore, is a fact case, isn't it? Until we can decide this case, we have to look at the facts, the evidence in this case that's been submitted under
In large part, yes, Mr. Justice, but I'm still trying to get some help from the background and the setting, which I repeat, it is not irrelevant that the concatenation of words here is the property of the United States, that this has been classified under executive orders approved by Congress, and that it obviously has been improperly acquired.
Well, that may have a great deal to do as to on the question of whether or not somebody's guilty of a criminal offense. I submit it has very little to do with the basic First Amendment issue before this court in this case.
All right, Mr. Justice, I repeat, unless we can show that this will have grave, and I think I would like to amend it. I know the court's order has said immediate, but I think it really ought to be irreparable harm to the security. And I own thought would be...
What's going on here is Stewart is attempting to winnow down the government's argument and find out exactly what the government's position is. Does the government claim a right to a prior restraint because the papers are classified? Answer, no, not by itself. Does the government claim a right to a prior restraint because it's their property? Sort of like copyright, done on government time by government employees, it's their literary product? No, the government doesn't claim an injunction based on that. Does the government claim it's entitled to an injunction because the materials were stolen, improperly acquired by the New York Times? Clearly somebody acted improperly for the paper stand up at the New York Times. Does that entitle the government to an injunction? Griswold says no. His point is that all three of these factors are relevant, but none of them individually and even collectively entitle the government to an injunction. So what is it that would entitle the government to a prior restraint? That's where we'll pick up on Thursday.